did it. I took 25 executive MBAs from around the world there, and right now it's just a construction site, but it's interesting. Who else wants to talk about it? Sal, did you go to the luncheon?
Yeah, I did.
What did you think?
Well, actually, I mean, it was my first time to so professional lunch in my whole life.
Wow.
Yeah, so I just don't know how to dress me. So.
These guys can help you. They know what to do. They show up in t-shirts, but they know how to dress when we go to luncheons. Ask them. They'll tell you what to do.
I really need to thank you. I mean, to invite me, give me the opportunity to join this lunch and introduce me to these developers. Thank you.
Yeah, you're welcome. Anybody else want to talk about it? Adela? Yeah.
I grew up in Aventura, and we definitely need this kind of project. And I believe this is going to be the beginning of changes in Aventura. I thank you so much for the invitation as well.
Anybody else?
Yeah, I also in Aventura. Every time I want to meet a client, is where should we meet for coffee? And I mean, it's talking where this place is actually what it's gonna. That's what it's gonna bring to Aventura.
Yeah.
And I met the other day with a German person who bought 2 apartments there, and they said that they only sold 40% of the residential. So imagine if they proposed 400 units. That's what they said.
Yeah, and I think it's 191, right, that they're building.
131 they're building.
Right, 130.
But they proposed 400.
Right.
Imagine how
What they would do right now, but they have sold out is like their retail office and
Right.
things like that.
Demetra, you want to say anything?
Yes, I wonder how much they bought the land there.
I have the number somewhere. I have the number.
Approximately.
103 or 113 million.
No, that's a construction loan. They didn't buy the land for that much. I don't remember, but I have it in my notes. Because I met with them before the luncheon. I have it in my notes.
it's probably 30% of that.
Yeah. They bought the land, but then because they sold that parcel off to the hotel, they were able to actually make money. Because they bought the land and then they did the zoning work. And then they zoned it as a hotel, and a hotel operator bought it, so they actually were able to make money on it. Yeah.
I thought something that was really interesting is why they chose to go to areas like Aventura, Hallandale, basically northern Florida, although they're around all of Florida. And it's because there's too much competition in land. It's too much of a saturated market. You know, you have these big players that can basically fix the prices and kind of determine where the market is going to go. So if you're, I guess, a medium-sized developer, a private equity firm as these guys are, you know, you can't compete. You know, it's especially when you're competing with the same money and same people that are trying. Because Latin America is small at the end of the day, and everyone wants to invest in Florida. So everyone wants to go to Miami. Everyone wants to say, you know what, I own part of this building in Brickell. I want to, whatever, Coral Gables. So, and I think it's very cool that they go to these markets such as Aventura and Hallandale, because being the first ones to do a large-scale development like this creates a barrier to entry for other people that are trying to come in, you know, and replicate those models. So I think that is how, stand out in how you make money is really finding the opportunity and becoming kind of the barrier to entry for other developers, right?
Yeah. Absolutely. It's a new product for Aventura. So, and so with that, anybody else? No. You know, the class, like real estate law, it's very document based, but the point of our program really is to get you out there and have you meet developers, have you meet people in the industry. You know, that's why I bring the guest lectures in, and have you gain applied skills that you can use right away in contact. So that's why we have the developer luncheon. We have that twice a year. That's why we have the boat tour, and that's why we have our guests come. So I'm glad you enjoyed it and took advantage of the opportunity. So with that, I'd like to introduce our guest lecturer. He's a great friend to FIU. He's spoken in my undergrad and grad classes for, I think, almost 7 years. We went to law school together. We graduated the same year. Michael Bernholtz, he's an attorney who specializes in landlord, tenant, and condominium cases. Specifically, Michael represents landlords in residential and non-residential eviction cases, and he represents condominiums in the collection of unpaid assessments, including filing of claims of liens and foreclosure lawsuits. So he represents landlords all over the state of Florida who own, maybe they own a few units or maybe a couple hundred units, and he represents them in their eviction lawsuits. Michael's a graduate of Cornell and the University of Miami School of Law, and he was a staff attorney with Legal Services of Greater Miami from 2000 to 2004, where he specialized in housing and poverty law. And like I said, I don't really care when you make an argument to me based on the readings, as long as you back it up. When Michael worked at Legal Services, he represented tenants against landlords using Florida Statute 83 Part 2. And since 2004, he's had his own practice, and he mainly represents landlords against tenants using the same body of law, Florida Statute 83 Part 2. So the ideas in law, you have to know, you have to be able to use your resource or your statute to be able to argue either way. And there's always a way to argue either way. Michael also is teaching at FIU Law School in the Medical Legal Partnership and Housing Clinic. So Michael, what's your fun fact?
Oh, I should have thought of one. Wow. I'll come up with one before the end of class.
He has a lot of fun stuff. Yeah.
I promise. I'm gonna start with I have a PowerPoint.
Or
If
with
that's
the
okay.
calendar, or can I give them a reading first?
Absolutely.
Who wants to read something for me? You want to read it? Mark? Okay. You're gonna have to read really loud, okay? So I'm gonna give you the mic.
But make yours small, because my
Oh, I'm sorry.
Yeah,
You got it on here?
yeah, this is what you have to read.
Okay. And I knew my rent was going to be late about a week ago. I worked my ass off, but still can't pay it done. But I got just enough to get out in this club, have me a good time before my time is up. Yeah. Let's get it now.
I remember
Get it now.
That's a song. Somebody wrote a song. Does anybody know that song? Yeah, I know what it is. Does anybody know it? No. Maybe Marcio's rendering of it wasn't good. Wasn't enough to.
You're here to make it.
I don't know how many. You can skip. Okay. Is this it? No. There was the one before. How about the back? No, it's wrong.
Just go back. Just go back.
Okay. There we
New
go.
Year's Eve, 1999.
Yeah.
How are you celebrating your Y2K?
What's everybody sitting here for? I mean, come on. It's New Year's Eve.
Papi, have you not seen? We haven't paid the rent in 2 months. Look at all these bills.
We go to the end of the month. I did a track on Coco.
Really?
You got the White House. You got the White House. You got the brief. I did a brief and I recorded it. I'm on first.
When we needed anything wrong, we paid the rent. We threw a rent party.
Tell you what, I got some highly house party. Spanish women. Let's ride.
I knew my rent was gonna be late about a week ago. I worked my ass off, but I still can't pay though. But I got just enough to get off in this club. Have me a good time before my time is up. Hey, let's get.
Okay.
Throw a party in my house.
So, we're going to talk a little bit about, I think that Pitbull did know about the Florida Statutes 83 Part 2 when he wrote that song. And we're going to talk about that throughout this class. We're going to go through a timeline of eviction and talk about why, although he knew his rent was going to be late a week ago, he went to the club anyway. Because we're going to talk about all the time that's involved in the eviction process. And we're also going to talk about the statutes too. But that's just to get you guys in the mood and to know that it's even Pitbull's talking about it on his songs. You won't forget Florida Statute 83 Part 2 because you'll always remember that song. Yeah.
Thank you very much.
Well, we've got a lot to cover, so I'm going to kind of jump right into it. As Professor Hollander said, I'm Michael Bernholtz. I have been doing a lot of landlord-tenant law for, I guess, going on, 16 years in one form or another. And it is important to know that I did represent tenants. I actually still represent tenants when I can, occasionally. So I get to argue both sides and use what I know, certainly from both sides. And what we're going to focus on tonight is Chapter 83, Part 2. I know you guys, I guess you went over Chapter 83, Part 1, at least as part of your discussion.
We went over more of the commercial lease because
Right.
commercial leases aren't regulated so much.
Right. Well, exactly. When you have a commercial relationship, the lease actually is going to really tell us everything. The statutes actually tell us very little. There's not a lot written.
And why did we say there's not much for commercial leases?
Because rent is based on the contractual agreement.
Why?
Well, it specifies what.
Well, it does that in this too, but why isn't there as much statutory regulation?
There's no standard.
Well, they assume that when you enter into a business agreement, you know what you're doing.
Yeah, that you're both big boys or big girls. You're both sophisticated because this isn't just for a place you live, but this is for a place where you're both business people, so you know what's going on. Whether that's true or not, that's not the issue, but that's why the Florida statute 83 Part 1 is so small, and it's also why I was able to teach commercial leasing in New York at NYU to a nationwide group because it's very not regulated around the country. It's more what the parties agree to.
Right, and in contrast, in Chapter 83, Part 2, when we're talking about residential, you're often dealing with a landlord, an owner, a property owner, a developer, a management company. You've got maybe one sophisticated party and maybe one party that's not as sophisticated. And we're talking about somebody's home. So it's given a certain level of importance under the Florida statutes. You know, this is important to both parties. It's where somebody lives. Obviously, if they lose the right to stay there, they may be rendered homeless. At the same time, from the owner's perspective, we're talking about an investment, which obviously has a lot of importance as well. So we're going to focus on the statutes. We're going to use them as a guide. We're going to actually read through a lot of the sections. So I hope it's...
I want them to know, because we have some people watching online or some people that own property somewhere outside of Florida. If you own property outside of Florida, the Florida statutes don't apply. So what you need to do is look for your statutes where you own property, your residential leasing statutes. The residential leasing is regulated tightly wherever you own property in another state as well. So the idea of this class, although we're focusing on Florida statutes, again, we're reinforcing reading critically, but also we're focusing on the resources. If you were to buy property in Georgia or Texas, you might want to research those residential statutes before you buy to make sure that you understand what the process is and what your costs will be involved in that.
Right. And Florida is sort of seen as a kind of a middle-of-the-road kind of state as far as balancing the rights and responsibilities of landlords with tenants. There's other states that I hear complaints from owners typically who say, you know, it takes me 3 months or 4 months to evict somebody in California or in New York, where it's a longer process. It's designed to give more protections to the tenant. There are also states that kind of move the needle the other way too, that give less protection. So Florida, and again, this is my reference, is Florida is the only place I practice, but I think it is a pretty middle of the road, intended to balance the responsibilities and rights of the parties. So basically what we're going to do is we're going to kind of walk through this. I may read through a lot of these things because I don't know do they have the statutes?
Have the statutes. I hope they printed them. We had a big discussion last week about if we print documents and statutes that we're reviewing. So yeah.
If you have them, if not, you know, especially.
We also have some excerpts on the slides, but if you have it, it's a lot better to mark it up. And it's better if you own property in the future, you own it now, to use it as a reference with the markup statute.
Right.
Yeah.
And again, as we get into this, you'll see the answers to most of the questions that we're going to have about landlord-tenant law can be found right in the statutes. They're designed to be understood by regular people. They're not supposed to be in legalese, and I think for the most part they succeed. We can all read them and understand the plain meaning of the words. It's not an area of the law that's dependent heavily on case law. It's dependent a lot on the statutes themselves. We're supposed to look at the statutes and know what it is and know what to do. So if you take the time to get to know these statutes, whether you're a property manager or an owner or a developer or a tenant, you will have a leg up on anybody else because so many people don't do that. You may not have as much of a need for me as an attorney because honestly I get so many questions that I want to say, if you bothered to read the statutes, you'd be able to figure this out. So I don't.
And we're gonna go through the highlights.
We're gonna hit the highlights, and we also have.
83 part 2.
We have a lot of material, so we'll get through what we get through. In any event, let's see. Okay, so again, chapter 83. There's actually 3 different sections. You guys sort of touched on part 1, which had to do with commercial or non-residential tenancies. We're talking about chapter 83, part 2. There's also a part 3 that talks about things like storage units or garages. We're not going to really talk about that tonight, but be mindful of the differences if that comes up, because I get questions about that a lot, where there may be an apartment that rents out like a storage unit inside the building to somebody if they want to store their things, or rents out a garage. That's going to be covered by a different set of statutes with different protections. And I won't even go there tonight, but it's kind of a different area. In Chapter 723, we don't have too many of these in Dade County anymore, but mobile home parks have a separate statute, because what you have in some situations is you've got somebody that actually owns the home itself, but they rent the lot that it's sitting on. So you've got almost like a hybrid situation, and again, the law is going to give different protections because you're talking about somebody's home that they have an investment in and they've got an interest in maintaining. At the same time, they rent that land from a park owner. Now, if somebody rents the entire thing from the park owner, the house and the land, it's going to be covered under Chapter 83, Part 2. So, moving on, we're going to jump right into it. The beginning part of Chapter 83 is...
And I'd like them also, you make it easy for them, but I'd like if you have the Florida statute actually to look at it with it and like highlight it, or... So we're looking at 43 part... Well, actually, what we're looking at, what's the name of that section? Chapter 83.43. What? Definition. Mario's exactly right. And we saw when we were in the commercial lease that the way that terms are defined in a lease isn't necessarily the way that we think words what they mean in everyday life. And we also would see that in a purchase and sale contract. A lot of times in a commercial purchase and sale contract, there's many pages that are set forth for definitions. So you think you know what does a dwelling unit mean, but the Florida statute has a whole section called definitions, and they're going to tell you when you're renting a residential tenancy in Florida what it means. They're also going to tell you what rent is and what the terms that we use, that even though we use them in everyday life, what they mean in residential tenancies in Florida. So it's always really important to look at definitions, whether in a contract or in a statute. Right?
I made a massive mistake by
Right.
not printing it. Can I
might have another set.
I can
do.
use it on my computer if you want.
I have another set. You can mark it up.
Thank you.
I may have another set or two as well, if anybody needs it. Don't be shy, because we are going to spend most of the night going through these. So
And I think that, I also think that the thing is that, just like last week, where you're not, most likely not going to have two real estate attorneys spend 4 hours going through a commercial lease with you, you're most likely not going to have a real estate attorney spend 4 hours going through the residential landlord-tenant statutes with you unless you're paying them their hourly rate. So I don't mean to bust anybody, but I'm going to, when you don't print your stuff and you come to class, you are the person who's losing. Because a lot of my students keep the materials that we use and they use it later in business. And then they don't need to call a lawyer for certain things. So when you don't print the materials, you're really missing out on your part of education. Yeah.
Okay, so again, if somebody wants to read what, a dwelling unit seems straightforward, but let's see what
do you want to read it?
Dwelling unit means a structure or part of a structure that is rented for use as a home, residence, or sleeping place by one person or by two or persons who maintain a common household. A mobile home rented by a tenant, a structure or part of a structure that is furnished with or without rent or as an incident of employment for use as a home, resident, or sleeping place by one or more persons.
So this is what's going to be covered by Chapter 83, Part 2. Okay, these are the types of arrangements that are going to be covered. It doesn't include some, I hope that makes sense. But it does include things like people that have a place to live furnished as part of their employment, like farm workers in some cases have those situations.
It doesn't include like a boyfriend who lets his girlfriend sleep over, does it?
It doesn't, I'm sure we could get into a whole class about those kinds of arrangements, where somebody who's invited to stay, a guest who stays in your home, or somebody who comes and doesn't want to leave, they're not going to be covered under Chapter 83. Okay, they don't meet the definition, and if we want to get rid of them, we've got to follow a different process.
And it's another statutory process. It's a squatter process.
Right.
Quick question, just for verification purposes. Anything over 1 of 4 units would be considered commercial leasing?
No, commercial leasing is understood to mean non-residential. Okay, not a place where somebody's going to live, someplace where somebody's going to operate a business. Right. There's no distinction on the number of units. Okay.
But in the Florida statutes, there's no distinction. But in your real estate exam, they say that anything over 4 units is commercial. And then for commercial financing, if you were to buy something, you would qualify for residential loan financing on anything under 4, and you would, which can sometimes be more advantageous, and then you would qualify for commercial anything over 4.
Yeah, that's how I was asking.
Right.
Yes.
Yes.
For the definition of the dwelling unit, the unit must be for renting purposes, or?
Yeah, that's what it says. It's rented for use as a home.
As a home.
So it's only considered for renting. If I own a property and live there, it's not.
Well, then you're owning it. You're not. Remember that we showed that, and I still have the image. The landlord-tenant relationship is an image of holding hands. The landlord's holding hands with the tenant. If you own the home, you're only holding hands, and you live there. There's only you. So you're not renting it. So this only deals with rental situations that are residential. Yeah.
And
Yeah.
number C, it means that if the property is not furnished, it doesn't belong to that category.
Furnished in this case means provided. It has nothing to do with whether it's furnished or not.
I'm sorry.
That's okay. Yeah.
That's a good question.
It's a great question.
Right.
Yeah, it can be. It doesn't matter whether it's furnished, unfurnished, and anything like that. If it's rented for use as a residence, whether it's a mobile home, whether it's an apartment, whether it's a big house, whether it's a boat in some circumstances, if it's rented for use as a residence, it's going to be covered under Chapter 83, Part 2.
There's also or without rent, meaning that I can give you for free.
No, it says as an incident of employment for use as a home. So it means, like, let's say you work in my restaurant. And I say, I'm going to let you, as part of working at my restaurant, I'm going to rent you a place next door. It's like as an incident to the business.
Okay,
So
like
it's related.
consideration.
Yeah.
Do boats count as mobile homes?
We should get into.
We're not going to get into that tonight.
Okay.
It's like home
I had a client that we had to evict. They were like Robinson Crusoe, and I'm like, I'm the Miami girl. They were so weird, and we had to evict them, and it was very difficult.
It brings up a lot of questions.
Keep your boat question. We can answer the break or something.
I don't have slides of it, but there are a couple other definitions that I'll point out real quick.
Well, and that's why we should look at the statute.
We'll look at the statute.
Right.
So, for example,
Let's see what does landlord mean? That's number 3. Adela, what does landlord mean?
Where are you? 83.7.
83.
Right, 83.43.
Number 3.
Oh, no. Landlord. Means thing. Means the owner or leaser of dwelling unit.
And
Okay.
what does tenant mean?
Tenant means any person entitled to occupy a dwelling unit under a rental agreement.
So, okay, so tenant might not be somebody who's paying rent. It might be somebody who's on the rental agreement, but maybe not paying, but living there. Right, okay. What else?
Rent, number 6.
Who wants to read rent? If I owned it, I would really want to know what rent means. Who wants to read that? Yeah, Daniel.
Rent means the periodic payments due the landlord from the tenant for occupancy under a rental agreement, and any other payments due the landlord from the tenant as may be designated as rent in a written rental agreement.
That second part of what you said becomes really important.
And why? Because we talked about it last week. Why is that important?
Additional rents,
What?
things like additional rents. Maybe when the owner of the property is trying to make amends, and when it comes in the case to like notice of evictions and things like that, it's really important because Jesus Christ, it's not coming right now, but I know it has to do with something like that.
Anybody else know why that part? If you can read it again, why is that so important? Yeah.
Because every agreement has different definitions for rent.
Right.
And this makes hard to make a comparison. If I say I mean rent in one agreement, in one lease, rent is defined differently than other. For example, it may include pesetas rent, additional rent and costs, and free rent, even free rent.
Well, that's in more commercial.
What about damages?
Well, the importance of this, I'll let Michael explain. I think that this is like, you should really underline it because a lot of people don't know, and it's very important. Right.
Right, I mean, I think we all have an idea of what the rent part is. It's this other part of things that might be defined as rent in the lease. Things like late charges, return check charges, certain other fees or utility bills. If they're deemed rent, there's a legal distinction that we're going to get to in a little bit that says if you don't pay rent, you can be evicted, okay? So rent is treated a certain way. So when we get to that point, if you're the landlord, you want to make sure, I would think, that you're defining certain things as rent. So if your tenant doesn't pay them, you have the same recourse against your tenant. You can go after them for failing to pay things like late charges and all those kind of things. If they're not defined as rent, you're going to have a problem, you may have a problem collecting them or evicting because of it.
I had to do an eviction once to someone, and that's the reason why in the 3-day notice I had to redo it
Yes.
and take off those fees.
Yes, we're going to get to that.
We're gonna get to that, but I think it's so weird. It's such a legalistic thing. Like, I wish I had a magic wand, because basically most people think rent is like the $1,000 you pay a month. But a landlord who read this statute says, if I evict that person, I don't only want to get the $1,000 a month. I want to get the late fees. I want to get the bad check fee, all those things. So I'm going to define in my rent, in my lease, that rent means the $1,000 a month and the late fees and the bad check fees. And if you don't hire an attorney and you're just doing a lease, most people would think when you sue for rent, you're just going to get everything. But this says that you don't. It depends how you define that term in the lease. And that's really picky lawyer stuff, but that's the law. That's how it is.
Right. Okay, rental agreement. This is another one, number 7.
Who wants to read that rental agreement? Want to read it? Wait. Do you want to say to somebody who has the statute? Or do we have another one?
I think I have another, there should be another copy.
Yeah, we have another one. Does anybody else need another one?
I got one more.
Okay.
Can I read it?
Yeah.
Rental agreement means any written agreement, including amendments or addenda, or oral agreement for a duration of less than a year, providing for use and occupancy of premises.
This is big, okay? Because this tells us it can be in writing or it can be oral. You don't even have to have anything in writing.
Do
Okay.
we think it should be oral?
Yes, it should.
No.
Do the lawyers think it should be oral?
I think, no, written is what I would agree.
What do you think?
Well, I prefer from both perspectives. I like to see something in writing. But the reality is that there are often times when you don't have something in writing. It happens.
So you still have a tenancy, even though it's not in writing. Yeah, Pedro.
How do you enforce it in a court of law?
We're gonna go through all of that because that's a great question. Okay, so I think we're gonna move on. So you get an idea.
Security deposits, or
Sure. Yeah. We'll talk about all those things. So basically, now that we know, we've got an idea of what we're talking about. The terms are defined in Chapter 83, Part 2. We know that we don't need something in writing to have a relationship, a landlord-tenant relationship that's going to have protections under the law. We also, you guys may also be familiar with different kinds of housing, okay? Much of what we're talking about is just general private housing where you've got an individual private owner, a private tenant. But it's good to be mindful of, at least, as we go through some of this stuff and in your careers, that you're aware of other types of housing, because there's going to be other protections and other rights and responsibilities. Things like public housing, where you've got the government or an agency of the government as the landlord, okay? Like in Miami-Dade, the Miami-Dade Housing Agency or the Miami Beach Housing Authority actually own properties where people live there. They usually pay very low rent, sometimes, in $10, $12, $20. It's based on income and it's based on certain things. There may be a long waiting list, and there's certain protections for that. Section 8 voucher is something that you're probably going to be familiar with if you get into management or development in residential properties. Particularly in Miami-Dade County, this has become even more important. A Section 8 voucher is a program, it's a federal housing program where a tenant is given an incredible government benefit, where the government typically pays about 2/3 of the tenant's rent, provided that the tenant meets certain requirements. And you're dealing with the private market. So the tenant has a voucher that they can go and they can take and they can live wherever they want, provided that the unit meets certain standards in terms of the amount of rent and certain minimum housing standards, okay? So you're dealing with a private owner, private tenant, but you're dealing with a government that's paying typically about 60 or 70% of the rent every month.
Why do you think some landlords really like it?
Because it's secure each month at least.
The government pays. The federal government, once the program is going, once you're approved, they pay every month on time.
And why does some landlords not like it?
Because they can't raise rent.
What?
You need to meet the standards.
Well, they're much more regulated.
Stringent,
They
yeah.
have much more regulation. What else?
You can't raise the rent on them, maybe? So it's contractually.
Yeah, well, you're right. Yeah, I mean, you're limited to, unlike private housing where there's no limit. We can talk about that. We don't have rent control in Florida.
I want to talk a little bit more about that. The leases that we talked about in commercial leasing, how long are they normally for?
5 to 10 years.
5, 10, 20, 30 years, right? How are the leases in residential?
1 year. At least 1
So
year.
could the rent go up every single year?
Yes. Why not?
And a lot of people like residential or like a business called multifamily, which is where they own many residential units, because if the market works with it, they can bump the rent every year. Is that happening in Miami-Dade County?
I think.
Yeah, it sure is. The rents are bumping. The rents, I think, are some of the highest in the country in Miami-Dade County right now.
Definitely.
And actually, the building that the Hollows are building behind us is going to be largely residential. The Panorama Tower is going to have a lot of apartment units.
Yes.
Yeah.
That voucher that you get, the government gives the voucher to the tenant and the tenant to you, or you get it directly from the government?
The voucher is sort of, I mean, there's nothing, there's nothing physical that happens, but the voucher is the benefit. The tenant can take that ability and take it to any place. And in Miami-Dade County, we had recently a change in the law that says there's what's called source of income discrimination, which means you as a landlord in Miami-Dade cannot refuse to rent to somebody on the basis of Section 8. This was a change, okay? And this is unlike other parts of the state. But in Miami-Dade, you can't use that as a reason, okay? It's seen as a discriminatory
Makes sense.
basis. So you really have to participate, unlike other places and whether you want to or not.
Somebody writes on the MLS, no Section 8 on a rental. And it's in Miami-Dade County, they're violating the law.
The other third has to be paid by the tenant.
Right, and the tenant must pay, the tenant still has the obligation to pay per the lease and has to pay on time, and if the tenant doesn't pay his or her portion by the deadline, the tenant can be evicted for not paying their portion of the rent.
Thank you.
How difficult is it to evict a Section 8 tenant?
It shouldn't be any different.
Not-
It shouldn't be any different, and I will tell you, I do it all the time.
Yeah.
So it works the same. Now, the difference is, for example, is that you have to notify Section 8. Okay, that's a federal requirement, not in Chapter 83. It's actually in the CFR 982, which you see up there. It's buried in like this fine print in this long Federal Register that says that if a landlord wants to serve a termination notice or a 3-day notice or wants to file a lawsuit, they must send a copy of that to Section 8. The reason is Section 8 wants to know about it. They want to know if the tenant's basically misbehaving, because the tenant needs to adhere to certain things. So if the tenant is being evicted either for non-payment or for some other reason, they want to know about it. If they're going to terminate the tenant.
Their benefits
Okay,
as well.
I had somebody call me today crying because she's getting evicted and she said, I'm losing my Section 8. And that's the reality. That's a disqualifying factor for the program. There's a 10, 20-year waiting list for people that want to get this. So it's an incredible benefit, especially in Miami-Dade where rents are so high. Somebody who's on a limited income, it's a tremendous benefit. And if you lose it, it's a big deal. Now they can appeal it and all
What
that.
I'd like to do is move from.
We're gonna move on, yeah.
Because it's not something that everybody deals with every day. We want to kind of do what people deal with every day, and then if you have
Right.
questions about Section 8, we can answer them towards the end.
Right.
Yeah.
Some other types of programs of housing as well. I'll make sure you guys get these slides as well, so that you'll have them afterwards. So we're going to move on. We've already talked about this. We know that a lease can be written or oral. It doesn't matter whether even if you don't have something in writing, it doesn't mean that the tenant doesn't have any rights or certain rights. The Chapter 83 Part 2 is going to provide like a baseline for the parties. Okay, it's going to have a structure.
We're still in 8343.7,
Yes.
which is still the definition section. So I want to stress how important it is. I said before, like there's some attorneys that only practice one kind of law, right? So Michael spends a whole lot of his practice in about these 28 pages. And if you own apartment units, you probably want to know the definitions of these 28 pages really well, right? Michael also practiced 718, I mean, a few other condo law, a few other places, but the definitions section about either a commercial document, a mortgage, a lease, statutes is really your first starting place, that you know what you're talking about. Right.
We talked about this already, that a lease, what a rental agreement is. And what I would say is, at a minimum, there's really 3 elements to a lease. We're talking about the description of the premises, the amount of rent, and the duration of the tenancy. Okay, so whether it's a street address or some other description, how much per month or per week or per year, and for how long. At an absolute minimum, that's what we need in order to create a landlord-tenant relationship, whether it's verbal or whether it's in writing. And this is sort of hidden here, but it says there's no right of rescission or a 3-day cancellation period.
Right, because I just taught landlord-tenant Rebecca in undergrad.
Right.
And we took a vote. How many people think if you sign a lease, let's say that Adela's a landlord, Eduardo signs a lease with her today, and then he goes home tonight and he has a nightmare that there's ghosts in Adela's property. Can he rescind the lease? Let's say that Eduardo signs a lease with Yopzal to be roommates, and then they get in a fight tonight. Can they rescind the lease and call the landlord and say that's why they're rescinding? No.
Unless there's a provision in the actual contractual
Normally,
agreement.
the provision of contractual agreement says if you make up, if you break up, if you fight with each other, if you get divorced, if you're married, if you do any of those things, the lease, you're still jointly and severally liable for the rent.
Everything
So even
goes
if
in
you
the
guys
way.
get in a fight, it doesn't matter. She's still going to say you're bound by lease. But I know you'd say it depends on if you got the keys, but still. Right.
Yes, I think, I've always said that you have to have performance under a contract. So, if they haven't taken possession yet, or if money hasn't changed hands, arguably, you're not there. But it's good to know, once you sign something, you're obligated, and you're obligated with the other parties, and you're gonna be obligated for the term of the lease, subject to whatever
Actually, yeah, I
provisions are
had
in
somebody
there.
in Maryland that just did that. She signed a lease, she made the security deposit, and they stopped showing the unit, the landlord stopped showing the unit to other people, and then she emailed like 3 days later, I changed my mind, I want my deposit back. And she said, I have a 3-day right of rescission, but in Maryland, there's no 3-day right of rescission either. So I was like, where did you get this idea from? But a lot of people have the idea when they sign a lease or when they sign a contract or a document that there's a right of rescission. And even in purchase and sale contracts, there's normally not a right of rescission. There's normally a due diligence period where you can back out for certain reasons, depending on if you negotiated that. But there's not normally, once you sign something and the other party signs it and you have a meeting of the minds, then you have a contract, right? Adela, let's say she runs her business renting units. Can she worry if the roommates are fighting? Then, or if she rents to married people and they break up, then she can't have her business anymore, right? So she has to take into consideration all their personal problems. So when they sign, they're normally jointly and severally liable.
I had a really interesting situation. My buddy and his girlfriend broke up while they were living together, and they jointly signed the lease. So they were both paying while my buddy was sleeping at his parents' house.
Oh my God.
Yeah.
And they were able to talk to the landlord and said, hey, if we find a replacement tenant that is willing to pay more than we are, would you be willing to terminate the lease? And he said, yeah, fine. So they found a replacement tenant.
Those things, I deal with dozens of those situations a year, because it's obviously common, things happen.
Yeah.
And it's something that you want to think about when you're signing a lease, and it's not the owner's problem.
When you sign any document with any other person, when you sign a lease, when you enter into an LLC, when you buy property together. In my undergrad class, we talk about love, marriage, makeup, breakups, and property. We talk a lot about when people own property jointly, married, and what happens when they end that marriage relationship with the property, right? So I think whenever you enter into any type of contractual relationship with anyone but yourself, you really need to think about what you're binding yourself to. What happens if that person doesn't pay? Are you going to pay? Or what happens if you guys don't get along anymore?
Right.
Okay.
Yeah.
But exists these 3 days for rejection agreement or no?
No.
And why people think that these 3 days exist?
I think in certain purchases, like if you buy a car, by law, there's like a 3-day period where you can change your mind, from what I believe.
If you buy a condominium, if you buy a condominium from a developer, there's 15 calendar days that you can change your mind from the date you receive the condominium documents. If you buy a condominium from an owner who's not a developer, there are 3 business days you can change your mind. So people might think that, but it doesn't matter, it's not the law, and it's not normally in a lease that says, Adele, you're in the business of renting places. You're going to wait 3 days to see if they really meant it, and then after 3 days they're going to tell you they meant it, but they're not friends anymore, so now they want to end the lease.
I've never seen it in a residential lease,
No,
ever.
never,
I don't think I've
never,
ever seen
never.
that.
Yeah.
In home purchases though, when you're dealing with like mortgages and things like that, you do have a 3-day
But that's
right of refusal, don't you?
that's not a rental agreement.
No, exactly,
That's
but in home
mortgages.
ownership, yeah.
Mortgages.
And that's why people have this idea that anything having to do with
Wait,
it.
cash purchase, after 3 days they can change their mind, private sale?
Yes, in a condominium, because it's the condominium law in Florida statute 718, that if you're buying from let's say that Sarah bought from a developer and then she's selling to you, you have 3 days from the date that you receive the condominium documents to rescind. And the idea is that you would read them and you would be like, oh my God, I can't have my pet or a barbecue on my balcony. I don't want to live here. But most people don't really read it. They just saying because
But usually you give those dogs within the process of, before closing, you give those dogs.
The law is that the buyer has 3 days from the date they receive the condominium documents to rescind. And if they buy from a developer, 15 days.
15 days.
So if it's a good broker who wants to get paid, they make sure that the buyer signs the purchase and sale agreement and signs delivery receipt of the condo docs the same day, so that clock starts ticking. Yeah.
Trying to get back to, I had a slide in there, but I can't seem to. Just finish. So weird, it's like stuff.
What are you looking for?
I was trying to get to this slide here.
Oh, okay.
I was trying to.
I have your slides too.
There we go. Okay, so this is where somebody asked a question about how do we know, how do we know how this oral arrangement is going to go? How long does it go? How do we change it? How do we terminate it? And there's really two different sections here that address non-written leases. First in 8346.
If you have the statute, I would pull it up, 8346. And I would be like writing on your statute like all the parts that we're going over.
Basically, what this is going to tell us is how we determine how long the tenancy is going to go for. So if somebody wants to read just 8346 subsection 2.
If the rental agreement contains no provision as to duration of the tenancy, the duration is determined by the periods for which the rent is payable. If the rent is payable weekly, then the tenancy is from week to week. If payable monthly, tenancy is from month to month. If payable quarterly, tenancy is from quarter to quarter. If payable yearly, tenancy is from year to year.
Okay, so this means that every period we're creating a new tenancy. Each time it's a brand new tenancy. So whether it's weekly, monthly, which is what's going to be in almost all situations, I think, quarterly, yearly, each time somebody pays rent, you're creating a new tenancy. Okay, so you may have a year where you've got 12 different tenancies. Okay, think of it that way. Think of it, you're always renewing that each time. Each time rent is paid and accepted, the parties are renewing their agreement under the same terms.
And why does it matter?
It matters because you typically want to know, how do we change it? How a landlord's going to say, how do I raise the rent? How do I get rid of this tenant? Or the tenant saying, I want to leave, but I have to give certain notice. What do I have to do?
So it matters if you're on a 12-month lease that's written. If the landlord, let's say that Arturo owns the building, Daniel's the tenant, and Daniel's paying $1,000 a month. He's on a 12-month lease. And Pedro buys the building in month 6. Is Pedro bound to let Daniel live there for another 6 months for $1,000?
Yes.
Yeah, he is. He's bound by the lease. But if Arturo said, you know what, I know I'm going to sell the building, it'd probably be more attractive to an investor if my tenants were on month-to-month leases. And then Pedro could say, Daniel, sure, you could stay if you pay more rent, and since you're only month to month, I don't have to give you as much notice. Under the statute, you only have to give 15 days notice before the end of before the new month, or the new time that rent is paid.
Right.
Or if you're in Miami Beach, 30 days notice.
Right, exactly. That's from 8357.
So sometimes in residential, landlords might want somebody to be on a month-to-month lease because it's more flexible, right? But sometimes like Pedro might say, well, I'd rather buy it with somebody already paying on a lease so I don't have to worry about renting it out.
Right.
So it just depends, who's buying it and the perspective of the landlord.
And that comes right from here, 8357 subsection 2, when the tenancy is subsection 3, when the tenancy is from month to month, by giving not less than 15 days notice prior to the end of any monthly period. So that means if rent is due on the 1st, okay, every month on the 1st we're creating a new tenancy that's going to go to the 30th or 31st of the month. Okay, if we get to around the 15th of the month, either party can say thank you very much, but I'm going to either move out or I'm going to tell you that you've got to move out by the end of the month. It always has to end at the end of a monthly period. Okay, it's not just 15 calendar days, it's 15 days advance notice before the end of the monthly
There's,
period.
I have a friend and she's getting divorced and her landlord, she's been living there a while and they're on a month-to-month lease because what happens a lot of times is the original term of the lease was 12 months and then the lease expires and then the tenant keeps paying the same monthly rent so it converts into a month-to-month lease. And her landlord's sending her, they say that we want you to sign another 12-month lease. And I told her, if you could avoid it, why don't you avoid it? Because right now, you want the most flexibility as a tenant. Maybe you'll move in with your boyfriend, maybe you'll get back with your husband, maybe you'll change your job. Right now, since you're only on a month-to-month lease, all you have to do is give 15 days notice. But then Michael knows about my condominium, and condominiums can regulate things. In my condominium, you're only allowed to rent once per calendar year. So I had a tenant and he was deported. And he rented, let's say, in month 7, July, and he was deported in month 9. Or maybe he rented in month 3 and he was deported in month 6. So we had until the end of the year, until the month 12, until December, I wanted to re-rent it right away. And the condominium units, the condominium association said, look at the condo rules and regulations, you're only allowed to rent once per calendar year. So for me, when I rent the unit, I prefer to rent yearly leases because I know if I rent less than a year, it will make things complicated. So it depends like what your situation is as a landlord, what kind of lease you want.
Right. But I mean, and think about that again. I get this from I hear from the tenants that are saying, my landlord, I may have been living this place for years. My landlord only has to give me 15 days notice, which is not a lot of time.
Some people don't like it.
Right, that's the flip side, is that it's not a lot of time. 15 days to pack up, find a new place, save up money, first, last security, pay that move in Miami-Dade County. It's not an easy thing to do for a lot of people, but that's what the law says. This is what the statutes provide. Okay, let's keep moving on.
Now what about the other way around? The tenant pays, and you want him to go away,
Are they on a month-to-month?
and you send the notice,
No, are they on a month-to-month?
month, and raise the roof.
Well, you can terminate the tenancy by giving 15 days notice.
He wants to stay still.
Then if you don't accept rent, okay, because every time you accept rent, you're basically accepting their tenancy.
What do you mean?
Well, then you can't accept the rent. If you don't want somebody and if you've given them a proper notice, I do evictions all the time where the landlord has properly terminated the tenancy, and once we get to the end of that month, I can file an eviction lawsuit against the tenant. And the judge will grant that, okay? Now, it's going to take a little bit of time. They're not going to be evicted the next day.
And we're going to do a timeline later.
Right.
Yeah.
But each time you accept rent, you're creating a new tenancy. So you can be doing yourself a disservice each time you're doing that. If you're saying, I don't want you here, and the tenant says, please let me stay, and you say, okay, then you've just voided out your termination. Let's see if we can. Doesn't want to.
Do you think?
Do I have a clicker?
Sorry.
We have a clicker. You can take it out.
It's really weird.
But we have our IT person here. Lloyd, it's not moving between slides.
Very strange.
One question. Have you found that the raising of property taxes has something to do with tenants not being able to pay?
I'm sorry, I lost that for a second. What was that?
Do you think the county raising or the property appraiser kind of appraising certain neighborhoods higher and taxing properties higher? Do you think that has something to do with certain tenants not being able to pay?
I don't
What?
know.
No.
Maybe you think.
Because they'll pass the.
But remember, there's a
cost of-
10% cap on the amount that the value can increase. So even if on the amount that the assessed value can increase, so it's not
It won't be
the
huge.
total, even if the values increase a ton, the total assessed value won't increase that much.
I can hit next.
And in residential leases, that's a good question. So we talked about how rent is described in commercial leases,
Oh,
right, at like $40 per square foot. And then you multiply that times 12 and you get an annual rent, and then you divide by 12 and you get the monthly rent, right? Without all the add-ons. But how is rent normally expressed in residential?
Monthly.
Right.
Monthly.
Right, like a gross sum, like how much?
1,500.
$1,500 a month. So that's normally what you pay the landlord. You don't pay in residential rent. You don't pay the landlord's property taxes. The tenant doesn't pay that. You don't pay the condominium fees.
Right.
Those things, right?
Right. And just one last thing about, when you're on somebody that's on a month-to-month tenancy, I get a question a lot is, how much can I raise the rent? Or how much can my landlord raise my rent? The answer is there's no limit under Florida law. There's nothing that says you can only raise it a certain percentage per year. There's no rent control, anything like that. The landlord has the ability to say, next month I want double the rent. And again, this may be a reason why you as a tenant want a written lease, because you want the protection from your landlord every month coming to you and saying, I'm raising the rent. But it's the same rules apply for changing the tenancy if you're going to raise the rent. Okay, so now that we've kind of talked about some of the reasons why we don't like having, nothing in writing, written leases obviously are a good idea, but there's some pitfalls and things to look out for. The first thing are form leases. I see a lot of different forms, some things that people buy at Home Depot, or Office Depot rather. They may be good or bad, and mostly they're not tailored towards Florida or for your particular use. So sometimes they may be an okay place to start, but there's often more to be done. Even if you're using the Florida, the realtor's lease, which is the lease that probably you all are familiar with, has a lot of good information, but I know if I'm representing a tenant or a landlord and I'm doing some revisions to that lease, there are a lot of things that I want to add, because there are protections that I think are missing from there. Leases for more than 1 year must be prepared by an attorney. It's
But
why
do you want to tell us what protections? I don't, yeah.
There's certain things in there. We talked earlier about things like late fees and things like bad check fees. The form leases generally don't say that those things are considered rent.
So the form lease doesn't use the magic wand and say late fees and bad check fees are defined in this lease, are considered in this lease as additional rent.
Right.
That means if you go to eviction, you're the landlord, you're suing the person, you can't get your late fees and bad check fees as part of rent. So a form lease is missing that. I think a form lease is missing the waiver of a
jury trial. Yeah, there's a right in Florida, for a tenant to demand a jury trial in an eviction case. They're pretty rare. I mean, you can imagine, but they do happen, and I did them years ago. And they provide a real. It can be a real block for a landlord. If you're facing a jury trial, it's expensive, it's time consuming. It seems ridiculous to many of us, to have a jury trial over sometimes a very small, relatively small issue. So you want to see in your lease a waiver where the parties waive the right to go to waive the trial by jury, so you take that off the table. So that's definitely something you want to see. Anyway, what you'll also notice, and I've pointed out 2 sections from Chapter 83. Are certain things that can't be in there.
8345. So everybody has a copy now, except you don't. No, you don't have a copy.
Of what?
Of the Florida statute.
Do I have another one?
Yeah,
I got one
do you
more.
want to have it?
Yeah, I like that.
Yeah.
I got a website for it.
Yeah, so, because you can mark it up, because Lloyd has investment properties, so, and tenants, right?
Yeah, I got 2 income properties.
So basically, even though the parties can make their own agreement, there are limitations on that. Obviously, everything has to be sort of within Chapter 83, Part 2, but there's 2 provisions, two sections that talk about unconscionable provisions and the prohibited provisions. And if somebody can read through 83.45, I think it's worth.
Yeah, thank you.
All right. If the court as a matter of law finds a rental agreement or any provision of a rental agreement to have been unconscionable at the time it was made, the court may refuse to enforce the rental agreement, enforce the remainder of the rental agreement without an unconscionable provision, or so limit the application of any unconscionable provision as to avoid any unconscionable results.
What does that word mean, unconscionable?
That it's not consent by both parties?
No, that's not what it means. that, because both parties signed the lease, so both parties consented to it. What does unconscionable mean?
Is our renters there, right? Like they were not.
No, I'd be like, the unconscionable means like it's
Something that offends kind of basic morality, basic decency. You know, we can think of something like if there were a provision that said if you were 1 day late, you had to pay a 100% late fee. Something like that, that said your rent's $1,000, if you come to me on the 2nd, you owe me $2,000. And even if the parties sign off on that and say, okay, I agree to this, okay, it is what it is, that's the kind of thing that would be unconscionable. That seems wrong. You know, it's almost.
It's something like.
Or if you damage the property somehow, they want to charge you $2,000 for a window, or something like that.
No. A window could be $2,000.
Well, $2,000 for a light bulb.
Right.
Yeah.
Would be unconscionable.
Okay.
You know, something very simple.
So it's like crazy to your conscience. You're like, that's impossible. That's not, the law couldn't uphold it, right?
And think about, you know, in all of this, think about if you had to go in front of a judge and you want to, you know, think about the things we see on TV, you know, who looks like the reasonable party. That's what most of this stuff is. Who looks like they're acting reasonably. So if you have a situation where somebody is putting something in, and remember the landlord drafts most of these agreements, okay? Almost all the leases are going to be drafted by a
Tenants read it? Have you guys, how many people here are renters? Did you read? Do you rent right now?
Average.
No, how many people are renters? Did you read your whole lease?
100%.
You did?
Yeah.
Good. Did you read it, Desi?
I actually created my lease.
I hope so.
I
Desi was in my undergrad class, so I hope so. Anybody else a renter? A lot of renters don't sign the lease, and that's unconscionable. Does not mean that they consented, because someone who gets a lease and the landlord says, "This is my form lease. Sign it if you want the place." The person just signs it, so they did agree. But unconscionable means it's just really, really, really not fair.
And I have tenants all the time that say, I didn't know that was in my lease. I didn't know it was in there. You know, if you sign it, you're basically agreeing to it. But this unconscionability provision is going to cover those things where the landlord went really out of control and put something that, you know, kind of offends kind of basic decency. And also in 83.47, if I can have somebody just read
And I
that
think,
section
you know,
there.
the inspiration for this law, remember when we were talking back about John Locke, and like, where do the property rights come from? Do they come from above? Do they come from your dad, who's the king? And when they did come from your dad, who is the king, and you had people living on your property, there were no rules that really made it fair between the landlord and tenant. So Florida statutes is not perfect, and some people think it's more pro-tenant, and some people think it's more pro-landlord. But it's trying to make it a situation where it's not like landowners and serfs, right?
Right.
With no rights. So you're saying
82.47.
Let's go there. Who wants to read 83.47?
A provision in a rental agreement is void and unenforceable to the extent that it purports to waive or preclude the rights, remedies, or requirements set forth in this part, purports to limit or preclude any liability of the landlord to the tenant or of the tenant to the landlord arising under law.
You can stop there.
Are we gonna go to 8367?
We can jump over there.
Okay.
These are the kinds of things, 83.47 is something that would be prohibited. For example, if the tenant said, if the lease said, in the event that the tenant falls behind in the rent, the tenant waives his right to the judicial process and agrees to be evicted immediately, something like that. You know, things like that you can't put in a rental agreement. You can't give up certain rights, certain things under Chapter 83. And I've seen where landlords will try to do it, say, you know what, I don't have to go to court with you. If you're behind, I just want you gone. And I want it written in there that you're not going to come back, and that you're not going to sue me, and you're not going to do this, that, and the other.
Why they like, if they try to write in, if you're behind on rent, I just want to kick you out, and you have to leave like the next day. So what that's doing is avoiding the whole eviction process, which we haven't gone through the calendar. And when we go through the calendar, you'll see why a landlord would want to put something like that in there. But it's illegal. You can't do it.
You wanted me to jump to 8367?
67, because it's in the same kind of vein.
It sure is.
Yes.
Okay,
So
so,
let's let them get to 8367, because they know that part of this class is learning how to read things that we don't normally read, right? So 8367. Who likes to read that?
A landlord of any dwelling unit governed by this part shall not cause directly or indirectly the termination or interruption of any utility service furnished the tenant, including but not limited to water, heat, light, electricity, gas, elevator, garbage collection, or refrigerator, whether or not the utility service is under the control or payment is made by the landlord.
okay, let's stop right there. So that means,
What does it mean though? Let's ask them, what does it mean?
Yeah.
Landlord can't shut off any of the utilities.
But let's say that it's included in the rent, the tenant's not paying rent.
Well, it's
Can you
saying,
shut it off?
no, you can't, it's prohibited by law.
Unconscionable.
Do you think people do it?
I would imagine that they do, but it's,
sure, it happens all the time. Landlords say, why should I have to pay his electric bill or his water bill or his cable bill, when he's not paying me? I'm going to make this real uncomfortable for him. He's not going to stick around if I turn the lights off.
Right.
What else are you gonna try to do? What else can't the landlord do?
Go to the next one. Number 2. I'm going to keep reading that.
A landlord of any dwelling unit governed by this part shall not prevent the tenant from gaining reasonable access to the dwelling unit by any means, including but not limited to changing the locks or using any boot, lock, or similar device.
So if I'm the landlord and the tenant hasn't paid, and I said, you know what, this guy, enough's enough. I'm just going to change the locks, I'm going to lock him out, make it, be done with him. Or put a big deadbolt
My
over it.
undergrad class said that the landlord lived in a condo and he changed the code on the access card so the tenant couldn't get in the elevator and couldn't access the parking. Could he do that?
so,
No. Now, what you can, there may be certain things that you can do as a landlord. You don't have to make it easy for them. Like if somebody's got a fancy fob and gets in, they go in through this special residence lane and they can go in and they can go up their special elevator and all that. As long as they can still access their home, you're probably okay. I generally don't recommend doing this kind of thing because the line, where is the line? And making somebody jump through so many hoops
And why
is
don't we
not so
care
good.
where the line is? Because what's the penalty?
Well, the penalty, if you go down a little bit,
Who wants to read the penalty? Don, you want to read it?
Sure.
Okay.
Which one?
if you go to, it's actually under number 6, which is down on, if you go to number 6.
A landlord who violates any provision of this section shall be liable to the tenant for actual and consequential damages or 3 months' rent, whichever is greater, and costs, including attorney's fees. Subsequent or repeated violations that are not contemporaneous with the initial violation shall be subject to separate awards of damages.
So what does that mean to you guys?
well, if you lock the tenant out of the property, of the home, then you're liable. But if I make it impossible or difficult, to access that property, I'm not liable.
Impossible is different than liable.
Well-
Impossible, you are liable.
Oh, impossible, yeah, like restricting, you can't get to the property, but if
I would not think about, kind of the line on this. Assume that you're violating, if you're limiting somebody's access, you're preventing them either from getting in, or you're shutting off their power or their water, or you're taking off the front
Let's
door.
say you're the tenant and he did one of these things to you. What are you gonna sue him for?
Breach of contract?
No. What are you gonna sue him for? What do you
How
want
much?
from him?
Oh, I want my,
3 months of rent.
That's all?
well,
What else does it say you get in there?
Everything.
everything?
No, what do you want? Everything's too broad. What does it say in the statute that you can get?
Whichever is greater, 3 months rent, whichever is greater in cost, including attorney's fees.
How much do you think Michael's fees are? You think he comes cheap?
I don't know.
I don't think so. I don't think so. So if you're the tenant, you could sue him for 3 months or your damages, and you can make a whole list of all the damages that happened to you and your family because these things happen to you, and it could be more than 3 months rent.
I've seen that where, you know, somebody, because they were locked out, they had to get a hotel, and because they were out of the possession, they lost, everything got stolen, and this one got, you know, all these things happen, and suddenly you've got.
And this is actually the only part of 83 Part 2 where the tenant is entitled to 3 months rent or more. This is the only part. Not for security deposit returns, not for anything else, only for this part, the prohibited practices part.
Right.
And what happens if the landlord does this and the tenant doesn't sue them? Does the tenant automatically get 3 months rent because this happened?
No, the only way you get it is by suing somebody.
So the tenant might not know that they can sue, right? They might not know.
How much is for them to sue a landlord? Because I know how much is to do an eviction.
But we're going to talk about that tonight. We're going to talk about that tonight because not everybody knows that. But yeah.
It depends. It depends. Okay, so let's
One quick question.
Yeah.
Is this the reason that most landlords want you to pay maybe the water bill or power bill?
It's exactly the reason that Michael has advised me, just for my residential unit, that I should always give it to the tenant with the utilities off. Because if I provide it to the tenant with the utilities on, and then I turn the utilities off, I could be violating this statute.
Right,
And in the condominium pays the water bill, but I would, try to do, some people don't want to, because if you don't pay the water bill, it could be a lien on the property, but.
Right. But generally, as the owner, you'd prefer to have all the utilities in the tenant's name. So if the tenant's not paying and gets shut off, which is probably a lease violation anyway.
Right.
You're not going to run into somebody making an 8367.
Right, if the
practices.
utilities are shut off, the light is shut off because the tenant doesn't pay, or the internet or the cable because the tenant doesn't pay, then doesn't pay FP&L, Florida Power and Light, it's not the landlord who shut it off. But if it's because the landlord doesn't pay Florida Power and Light, then it is. Right. But good question. Yeah. Yes.
Recently, one of my properties, we received a letter stating that I would guess the previous owner didn't pay the water bill. We received a letter that the water bill is due almost $1,500. And we literally just got this property 2 months. So right now we're trying to fight it to see if we have to pay it or somebody else who's actually responsible for it.
It's going to depend on a lot of things. You probably can get FP&L to.
Water bill.
Oh, I'm sorry, water.
Water.
Water, you can probably get them to take care of that. But you probably also have a claim against the prior owner for not paying it because depending on what your contract said.
What's in your purchase and sale contract, and also to see who reviewed. Sometimes the attorneys don't review the municipal bills, and you might have taken it subject to that, but you can go to the water department and see what they could do.
They will usually.
Right. Normally, sometimes they'll give you a break. The first thing you should do is look at your purchase and sale contract and call your closing attorney and tell them.
Okay.
Okay, we're going to jump back now to basically landlord rights and responsibilities. So now that we've got a lease, we're moved in, everything's good, everything's great. But what does the landlord have to do? And the first thing.
And let's let them turn to 8351 sub 1. And if you, how many people here would like to buy like an apartment building? Do you think it's important to read this kind of stuff before you buy it?
Of course.
So 8351 tells you what the law says that the landlord has to do.
This becomes really important because there's really kind of two different things. Does somebody want to read through 8351 subsection 1?
Andrea, you want to?
The landlord at all times during the tenancy shall comply with the requirements of applicable building, housing, and health codes, or where there are no applicable building, housing, or health codes, maintain the roofs, windows, doors, floors, steps, porches, exterior walls, foundations, and all other structural components in good repair and capable of resisting normal forces and loads, and the plumbing in reasonable working condition. The landlord at the commencement of the tenancy must ensure that screens are installed in a reasonable condition. Thereafter, the landlord must repair damage to screens once annually when necessary until termination of the rental agreement.
That's fine. So that's sort of the most important stuff. And the reason there's going to be a distinction between subsection 1 and subsection 2, if you're a tenant, these are the things that your landlord has to provide, and if your landlord doesn't do these things, you may have the right to either terminate the agreement, the lease agreement, or to withhold rent. Okay, but it's only for those things in 8351 subsection 1. But if you look at that, that includes a lot of things. I mean, that's pretty, that's the major stuff. You know, that's plumbing, that's,
But it is plumbing, but it's not plumbing, right?
right.
Why? Because what does it say about plumbing? What? You got it in there. What does it say?
Reasonable.
No, say all the 3 words.
Working condition.
No, the whole thing.
Reasonable working condition.
Plumbing in.
Reasonable working condition.
So if the landlord gave you an apartment that the plumbing worked, right? And you decide to wash your clothes in the toilet, or have a party and have, 50 people use the toilet, and then the toilet overflows, although it was a 1-bedroom apartment, would it be the landlord who's liable? Why not? What would the landlord write you? Right, Sarah, the landlord would write you, I only have to do it in reasonable working condition, and what you did was not reasonable for using a toilet in a 1-bedroom apartment.
And the landlord also has to provide, and these are things in the statute. It also, if you have a lease, you can write other things in there too. Okay?
But the landlord doesn't have to write other things in
No.
there. Right.
No.
So should we go to 2A?
Yes.
Okay. Who wants to read 2A? Eduardo.
Unless otherwise agreed in writing.
And those are the most important words in this part, so read them again.
Unless otherwise agreed in writing, in addition to the requirements of subsection 1, the landlord of a dwelling unit other than a single-family home or duplex shall at all times during the tenancy make reasonable provisions for 1. The examination of rats.
No, extermination.
Extermination of rats, mice, roaches, ants, wood-destroying organisms.
Okay, let's go
and
to
bedbugs.
2. Let's go to 2.
2. Locks and keys. 3. The cleaning and safe condition of common areas. 4. Garbage removal and outside receptacles, therefore. 5. Functioning facilities for heat during winter, running water, and hot water.
So what does the landlord have to do according to this provision? Why do you say that, Pedro?
Unless it's written and
Right,
agreed.
unless it's written. So I had a student who called me. Who was my children's student? She called me and she told me that she moved into her apartment and there were bugs in her apartment and she wanted the landlord to pay for the extermination. And he said he wouldn't pay, that she had to pay for it. And she sent me over her lease, and in her lease, she agreed that she would pay for the extermination. Because it says, it's written confusing, right? It says, unless otherwise agreed in writing, and then it says the landlord shall. But it means if it's not agreed to in writing, the landlord doesn't have to do this stuff. So some people that are landlords sign leases that have them doing these 5 things, where really the landlord doesn't have to do it unless they agree to it in writing.
Doesn't it say that unless they do it in writing, meaning if there's no writing, the landlord has to?
No, read it again.
Unless otherwise agreed in writing, meaning when there is no writing.
Right, if there is no,
If there is no writing.
right, if there is no writing,
The landlord of a
would have to
dwelling
do
unit.
it.
Unless the parties agreed otherwise, meaning they shifted the burden
If they don't,
from the
if they don't
landlord,
shift it, the
then
landlord
the
has to do
landlord
it.
does
Right,
have
so
to
if
do
you
it.
have a oral lease, then the landlord would have to do these things.
What does it say in a dwelling unit other than a single-family home or duplex?
It does say that.
Sorry, you're looking at Now your question on that. Where was that?
It's in 2A, the second sentence.
I'll read it again. Unless otherwise agreed in writing, in addition to the requirements of subsection 1, the landlord of a dwelling unit other than a single family.
Okay, so we're talking about multifamily apartments, buildings with multiple units. So it does not apply to single-family homes or duplexes.
So if it's an apartment, for example.
It would apply.
This would apply.
Yeah.
The landlord, these are things that are also required unless the parties agree in writing to shift the responsibility. So you'll see leases like what she was talking about, where you can have a tenant's, the burden for taking care of pest control can be shifted to the tenant, for example. And if that's the case, and the tenant says, my place is infested, if the tenant agreed to it, if it's in the lease, landlord gets a pass. The things in subsection 1, those are things that can't be shifted. The landlord can't say to the tenant, you have the responsibility for keeping,
So in section 1, it was kind of like a must-dos. The landlord must do these, must do them, shall do them, shall, the law means must. In subsection 2, it's saying if the landlord and tenant agree in writing, then the landlord will do these things. But if the lease is silent, if the lease doesn't say anything, does the landlord have to do these things?
Yeah.
No.
Because they didn't agree in writing.
I think it doesn't mean that.
You think it's wrong?
I think it means unless otherwise agreed. Unless it's been shifted.
Okay, I agree with him.
These are the things that can be shifted. And you'll see that sometimes. Sometimes you'll see where the landlord will say, you know what, I don't want to take care of pest control is a typical one. Or they'll say, locks and keys, or you're going to have to clean up the common areas. You're going to have to mow the lawn, for example. The landlord can shift that responsibility. They can't shift the things in one, okay? They can't shift care of the exterior walls. They can't say, there's a hole in the wall, and the landlord can say, you're going to have to take care of that.
Unless the tenant created the hole.
Unless the tenant created the hole, yes.
It comes out of the deposit.
Yes.
Right.
Could, yeah, sure.
Pedro.
So I was with that, I was confused, so just to clarify.
Yeah, read again because this class
Right.
is really about reading, right, yeah.
So if I want to avoid having to pay any expenses with regards to exterminating or keeping lock and key, I have to specify I will not do this, and we agree, and.
Put it in the
You don't have
lease.
to say I will not, you could say tenant shall.
Okay, yeah.
Yeah, exactly.
Right,
You write
tenant
it,
shall.
write it, more positive.
And I wouldn't.
That's it.
I'm very
I'll make it look
straightforward.
better. Right. Okay, so just to point out real quick, I know we usually talk about this. We see in here that it says heat during winter, for example. Landlord's got to do that.
This is in Florida statute. It says the landlord has to provide during winter unless they agree that they don't have to in writing.
Right. But what about something like air conditioning? It seems a little weird. I haven't turned my heat on in years here. But I have air conditioning, and I assume most of you do too. What if there's no air conditioning? Is it required under the Florida statutes?
No.
It's a luxury.
It's a
I
luxury.
think, yeah.
Well, it's interesting because it's not required. So I can furnish an apartment. I can rent an apartment that doesn't have air conditioning in Florida. There's still some that are out there. Maybe they have fans and the old jealousy windows and all that kind of thing.
Yeah,
That's legal.
We have to put AC in the duplex we bought.
You're not required to do it under the
Right.
statute.
Right,
You may be
you can
doing
tell-
it because your
Right.
tenants will demand
You
it.
can tell someone to bring their own window units. You
Sure.
can say, I don't provide AC.
Right.
Then if you have ventilation, it's okay.
Then maybe okay. Yeah. But it's not required. Heat is required. You have to have a heater.
So this
But you don't have to have air
one
conditioning.
of number 2 is kind of like number 1 are the must-dos, and number 2 is the default. If the landlord didn't wiggle out of them in the lease.
I like that. Wait, I like it. Yeah.
It's what you default to under the law if the landlord didn't know that they could shift that burden in writing under the lease.
These are.
Right.
I feel like they should change the statutes
Yes.
to make air conditioning the same as heating.
You think, right? Now, and we're gonna get to this. What if? Okay, so now you've rented an apartment that has air conditioning, and the air conditioning breaks. Okay, what do you guys think about that? Can a landlord say, "Aha, statute says I don't have to provide. What do you guys think about that?
No, because I think the dwelling becomes uninhabitable because of the mold and all the crap that grows when there's no air conditioning.
You're right, but the reason isn't necessarily because it becomes uninhabitable, because we could have rented it without air conditioning in the first place.
Yeah.
But if something is there at the beginning of the lease, you probably rent it because it was there, and there's an expectation that it's gonna continue to be there, it's gonna continue to work. So a landlord's not gonna get a pass by saying, aha, I don't have to provide air conditioning, your AC broke, sorry, not my problem. That's not gonna work, okay?
What if the landlord just shifts the burdens in case the AC breaks to the tenant?
There you go.
Can you do that?
I think you can. According to the statute, you can.
So if I put in, let's say I put in a brand new central AC and it breaks 3 months after they move in, I can put in an agreement that, hey, you gotta pay for that now.
I think what most people do, they say that if there are, they write it in a way that if there are repairs, that the tenant, this is how they write it, the landlord will pay repairs up to $50.
Right. Like a deductible.
And then what it means is that the tenant will pay anything that costs more than $50. So a tenant might say, I'm not gonna agree to that, I want the landlord to pay repairs up to $300 or something. I'm not like anything costs $50 when you call somebody out to fix it, right?
Mm-hmm.
So sometimes that's the way that they do it. They say like if there are repairs, or then they say if the AC breaks or anything that furnishing breaks because of the tenant's misuse or negligence or not using for the intended purposes, reasonable purposes, the tenant is fully liable to pay for those things.
Right. So remember, you can put those things in there. You're also going to run into what we talked about earlier, those unconscionable provisions. You can't put certain things in there.
Okay.
Typically we see this like where the tenant's required to maintain the AC. They're required to change the filters every
Let's say
month.
that the AC does break, and let's say that Mario's the tenant, and he says, it's taking Lloyd too long to fix it. I'm just going to pay for it and fix it, and I'm going to deduct the $200 it costs from my rent. Can Mario deduct, because he needed the AC, can he deduct that from his rent?
No. And we've just gone ahead, which is good, because this really segues nicely, she's done this before, into what if your landlord is not meeting its obligations under the law and under your lease, okay? And this is the one part of the statute that I've never liked the way this is organized, because it actually comes from two different places.
So let's go there, 8356.
One quick question, would it be unconscionable to use like size 2 font and wingdings in your contract?
I think it would. If you're intentionally trying to mislead somebody or have them not be able to read that or skip over it, sure, yeah, absolutely, absolutely.
I mean, but have you seen a lease? There's a lot of leases. How long is your lease for your unit? I mean, how long is the lease?
Maybe 5 pages, 6 pages?
A lot of leases with big companies that own 300-400 units are 15 pages long, and they're legal size. The font's not, as tiny as you said, but it's still intimidating for someone to
Legal
read.
size 110 font?
Probably, I don't know. The font's not regulated for leases like it was for property appraisal.
So basically, if you as the tenant, you think your landlord's not doing what they're
So
supposed to do.
Mario said, I can't live without AC, I'm just gonna do self-help and fix it, and then I'm gonna get back at Lloyd, and I'm gonna deduct it from my next month's rent.
No, you can't do, that is unfortunate, you can't do that in Florida. There's no repair and deduct, there's no self-help. But the statutes give us a guide in two different areas on what we can do to try to force our landlord to make repairs, okay? That's what this is intended to do. It's intended to provide a remedy for the tenant to force the landlord to make repairs. The idea is we want this to work, or the legislature, when they wrote the statutes, we're trying to make these situations work, okay? And that's the goal here. So you've got two different sections of the statute where this right comes from. The first one is found in 8356 subsection 1, okay? This is basically if your landlord's not doing what you're supposed to, you give them notice, and we're going to read through this, and if the landlord doesn't fix it by the end of a 7-day period, you can consider the lease terminated. And 8360 is actually a very similar process, but instead of considering the lease terminated, the tenant at that point has the right to withhold all or part of the rent. okay? There's still never a right to just go ahead and say, I'm gonna deduct $300 off my rent because I had to pay this, or I had to suffer for 3 days without air conditioning.
Excuse me, can
Yeah,
can I return from something?
Yeah.
Okay, I was thinking about extermination of roaches, for
Yeah.
example. And this is obligation for the landlord, right?
Is the extermination obligation for the landlord? Well, there's not a yes or no answer. What's the answer?
If it's
It
regular.
depends on how it's written in the contract.
So, for example, it is in the contract, what happened with the tenant at the time for, when the exterminator tried to exterminate the...
If it is in the contract.
If
If it is, if the landlord wrote in the contract that the landlord will take care of extermination.
So what happened with the tenant, stay in a hotel, or what happened?
We actually skipped over that just because we got so much material. There's actually, we can go back there. I mean, I can talk real briefly. This is actually in 8351 subsection 2.
But now,
It says right here, okay, when vacation of the premises is required, which may be like if they're gonna tent, like for termites or for roaches or something like that, or if they're spraying and the tenant has to leave, okay, when vacation of the premises is required for such extermination, the landlord is not liable for damages, but shall abate the rent, which means they have to give them a rent credit, like a prorated rent credit for each day that they're out. And the tenant must temporarily vacate the premises for a period of time not to exceed 4 days on 7 days written notice if necessary for extermination pursuant to this subparagraph. So as the landlord, I have the right to tell you as the tenant, okay, I make the decision. You tell me there's a problem, I get to pick the remedy. Okay, the tenant doesn't get to pick the remedy. I say, you've got to move out. Okay, I'm going to give you 7 days notice. We're going to come in and you're going to have to leave for 4 days. Okay?
and your rent is $1,000 a month. So how much is the landlord going to pay you for 4 days, even though you stay at a hotel? It tells you.
It tells it right here.
Okay, 4 of 30 years?
What?
No, 4 of 30...
$1,000 rent.
Prorated, right?
$1,000 per month.
Prorated.
So what does this say? How many days?
4 days. On 7
Oh,
days.
sorry.
7 days.
No, not to exceed
Not
4
to exceed
days.
4 on
That's
Sunday.
But we're saying 4 days.
4
That's
days.
how it's gonna. That's how long it's got to be.
So 4 times 30, right?
Mhm.
Prorate, you prorate
So he's going to give you
$1,000.
120 off your rent for
So
moving
they-
out for 4 days. Even if you have to stay in a hotel.
Where did you get that? You said you divide by
By 12.
30.
Oh, by 30.
30.
Oh, I'm
30.
sorry, by 30.
30, whatever. Somebody will tell me that comes up to what? 300? What?
$30 a day.
33,
Right,
something like that.
times 4.
Times 4. You're right.
Right, yeah.
Yeah.
It's about 120. So you stayed at a hotel, you spent 150 a night at a hotel, and you give Lloyd your bill for 4 nights at 150, and he says, I'm going to follow the statute and do exactly what's legal, and I'm going to pay you 120.
That's not going to cover the tenant. The tenant's going to say, what do you mean? I had to spend 150. This is Miami. It's season. I can't find a hotel that I want to stay in for 4 days, $140 a night.
Unless you want to bring bed bugs back to your
There you go.
I think what we're going to have to do, because people are going to have to stop now, and because I think the restaurant's going to close downstairs. And then we're gonna stop for like a half an hour, and then we're gonna start back up. So we'll be back in class at like 7:45.